Morning, everyone. Welcome to today's webinar. Today's topic is Ask a Pro, Navigating Chapters 7 and 13 Bankruptcies, Part 2. I'd like to thank those of you that attended Part 1 of the series back in November for returning for today's session. And in case you missed the first session, we will be sending a recording along with the recording for today's session at the conclusion of the webinar, so you can hear both of them. I'm Scott Fink. I'll be the moderator for today's panelists and for the session. I'm a shareholder in the firm's bankruptcy practice group at Weltman, Weinberg & Reese. In managing the practice group, we focus on both consumer and commercial bankruptcy filings from the creditor side. And I also have some involvement in our firm's real estate default group. I'm a member of the Cleveland Metropolitan Bar Association and the Ohio State Bar Association. And just very pleased to have all of you on the webinar with us, and we look forward to sharing what we know with you. So before we get started, I want to just take a moment, go over a few housekeeping items. So as a reminder, it's an interactive session. Please submit your questions through the question button in the control panel. I would also like to thank everyone who submitted questions in advance during registration. We will do our best to address those throughout the presentation where applicable. And to the extent we don't get to yours or you don't get it answered, you'll have our contact information when this is over, and you can reach out to any of us, and we will be happy to talk with you either on the phone or by email with any additional questions you might have. The webinar is being recorded, and at the conclusion of today's session, again, a link to the recording and a copy of the slides will be sent to all attendees. So now let's learn a bit more about the panelists. Let's start off first with Monette Cope. Monette?
Good morning, and thank you for attending our Ask a Pro seminar. I've been an attorney since 1988, and I've been with Weltman since 2000. I have some background in real estate, but my primary career focus has always been bankruptcy. I started as a staff attorney for a Chapter 13 trustee, and after that, I have mostly only represented creditors in bankruptcy. I engage in routine matters such as motions for relief from stay to complex litigation in bankruptcy. I have a lot of experience and knowledge, and I'm really looking forward to sharing what I know with you today.
Thank you, Monette. Milos, why don't you tell us a little bit about yourself?
Hi, my name is Milos. I'm an attorney. I've been an attorney here with Weltman for about 5 years. I've been practicing law for about 16, all of which have been bankruptcy related. Half of that time, I actually represented individual debtors in bankruptcy, and the other half, I was a creditor's attorney. I'm a member of the CMBA, and I currently sit as the chair of the Bankruptcy and Commercial Law section of the CMBA.
Great. Thank you, Milos. Last but certainly not least, Garry Masterson.
Good morning, everyone. I'm Garry. I've been with Weltman in one capacity or another for about 4 years. I actually started with Weltman in management before starting to practice with Weltman. I handle bankruptcies in Pennsylvania, New York, Ohio, and all of California, and I'm also licensed at a state level in California.
Fabulous. Thank you, Garry. All right, so without further ado, let's get into the first question. The first question will be fielded by Garry. Garry, can a creditor file a motion for relief from stay if they miss the proof of claim deadline?
No, if you miss that proof of claim deadline, you cannot file a motion for relief from stay. Generally, the lien will survive the bankruptcy, but you cannot proceed against your collateral until the debtor receives their discharge or until the case is dismissed. However, I would add, even if you miss that proof of claim deadline, based on my experience, I would recommend reaching out to us, and we can try to correspond with debtors counsel to see if they're amenable to us filing a late claim. 9 times out of 10, they have no issue with it. That's especially true if the plan is providing for your claim. Generally, they have no problem. But make sure you hit the deadlines, both for your claim and for the possibility of filing for relief later. But as I said, if you miss in one-off situations, we are more than happy to reach out, and usually debtors' counsels have no issues with allowing the late claims.
Perfect. Thank you, Gary. All right, the second question is going to be for Milos. Milos, what should a creditor do if the debtor's in a Chapter 7 or 13 bankruptcy and the collateral is not insured?
My belief is if you know the collateral is not insured, is underinsured, or you are just unable to get confirmation that it's covered by insurance, I think you should take immediate steps to protect yourself from the collateral. First off, if you have the ability to obtain your own insurance to protect the collateral, that's always a good idea. I would recommend doing that. And in addition, debtor is required to obtain and keep insurance for the pendency of the bankruptcy. So if they fail to do so, that's typically grounds for relief from stay. So my suggestion is always that you seek immediate relief from stay and put the pressure on the debtor and their attorney to get the insurance or provide you with proof of insurance. In addition, typically when we file those motions for relief from stay as part of the, if the debtor and his counsel want to resolve that, typically we require them to reimburse you for any out-of-pocket expenses that you had to ensure the collateral yourself. If you wait too long to file a motion for relief or take action, you're just increasing and accumulating the costs out of your pocket, which makes it more likely the debtor will just walk away from the collateral and leave you with unpaid insurance costs. So I think it's in your best interest to, if you can't get proof of insurance right away, or you know for a fact that it's uninsured, I'd file for a relief right away. In a 13 context, there's a possibility of filing a supplemental claim or asking for post-petition costs for your out-of-pocket insurance that you paid for the to insure the collateral. But the problem there is, unless you resolve the issue with the debtor obtaining insurance, that's going to be a continuous thing. So you're constantly sinking money and losing equity by doing that. I think the aggressive approach is the best approach, enforcing the debtor's hand.
Number 3, one is from Monette. Can a creditor continue to pursue a non-filing codettor if the other codettor has filed for bankruptcy? So in other words, one's in bankruptcy and one's outside of bankruptcy, and they're both on the loan together.
Okay, the short answer is yes, with a twist. Of course, there's always a twist in bankruptcy. In Chapter 13, there is what's called a codettor stay. And what that means is that you cannot collect against a non-filing cosigner if the other cosigner files Chapter 13. It also only applies to consumer debt, not to business debt. So my example is dad co-signed a car loan for his son, and son files a Chapter 13. There is a codettor stay against repossessing the vehicle or collecting from dad until and unless you get relief from codettor stay. So the way this plays out, I've got 2 examples for you. One is son files his Chapter 13 plan and he lists the debt as contingent. He says, I'm not paying this. Dad's got the car. Dad's going to pay it. Bye-bye. Okay. What you want to do in that instance is you want to get both relief from stay as to the son and codettor relief as to the dad, so you can deal with dad outside of bankruptcy without dealing with the son's bankruptcy. Another very common scenario is if the son says, I've got the car, it's mine, I want to protect dad, I'm going to pay it, I'm going to pay it outside the plan. That's how I'm going to do it. And then the son defaults on the payments. Again, you want to go in, you want to get a motion, file a motion for relief and a motion for codettor relief as to dad, so that you can repossess the vehicle. And then once you sell it, you will have a deficiency balance. Now, you have relief from codettor stay, so you can pursue the dad for the deficiency balance in state court. And you can also file a deficiency claim in the son's bankruptcy. So you'll have two sources to collect on that deficiency claim if you so choose, but of course you can only collect up to the balance. You can't double down. Now let's switch gears and talk about Chapter 7. There is no codettor stay in a Chapter 7, but you still have to be careful. So let's go back to dad and son. So if you want to retrieve the collateral, the car, you have to file for relief against the son. There's no codettor stay. You could pursue the dad outside of the Chapter 7 without any relief for the balance of the debt. But if you want to get the car, you have to get relief as to the son. Sometimes you're going to run in a situation where there's jointly held assets. So very common situation, husband and wife own their home. They both sign the note and mortgage. Wife files for bankruptcy, but husband does not. You can pursue the husband in state court for the debt, but if you want to file a foreclosure, which you probably do, you will want to get relief from stay as to the wife in order to pursue them both in foreclosure. The other scenario is an unsecured debt. So say husband and wife again, they both owe on a credit card. Wife files Chapter 7, husband does not. You can sue the husband in state court without any relief whatsoever on that unsecured debt. There's no jointly owned collateral, assets. You can just go after the debt. So 13, there is a codettor stay. You have to deal with getting relief from codettor stay to move against the non-filing codettor. Chapter 7, there is no codettor stay, but you also have to be careful to get relief as to the actual debtor.
Thank you, Monette. And I will add, while it's not the topic today, we're limited to 7s and 13s in our discussion, just so everybody knows, the codettor stay also exists in Chapter 12, which is typically a family farmer bankruptcy. It does not exist in Chapter 11. So there is no codettor stay in 11. Just wanted to make sure everybody's aware of that as well. Okay, so question number 4. This one is going to be for Garry again. How is it determined how much an unsecured creditor will receive in a Chapter 13?
So as a unsecured creditor in a 13, what you're going to receive is the minimum of the amount that you would have received if the debtor had filed a Chapter 7 instead of a Chapter 13. Now, that amount that you actually receive, so that's the minimum. The amount in practice that you actually receive can vary greatly. You can have a 0% unsecured plan, which means the debtor is proposing that there will not be any funds available for you as an unsecured creditor, and you will likely not receive any payout on your claim and your debt will be discharged. Then it could range anywhere from that 0 to 100% unsecured plan. Another item that you can see many times in a plan as far as unsecured is the unsecured creditors will be treated.
Oh, poor Garry, he froze. Oh, see if he comes back. All right, well, I'm going to fill in for Garry for a second and just add for the unsecured treatment in a Chapter 13, one of the other things to keep in mind, it's kind of a multi-pronged approach. The first, as Garry pointed out, is the Chapter 13 trustee is going to conduct an analysis, essentially do a hypothetical liquidation of the Chapter 7 debtor to say, what would happen if this individual were in a Chapter 7? What property or assets does he or she own, and what exemptions can he or she claim against those assets to protect the equity that they may have in those assets? And that then gives you that bare minimum, that number that is the non-exempt value of their assets. That is call it the floor. That's the minimum amount they have to pay to their unsecured creditors in a Chapter 13. The second piece of it, though, of course, is you also have disposable income potentially as a Chapter 13 debtor. So if you spend less than you make, so if you make or bring home $2,000 a month and you only spend $1,500 and you've got $500 of disposable income every month, you better be devoting that to the plan, or you're going to draw some objections from the trustee and from your creditor. So it's kind of a multi-prong. There's a floor, and then there's a further analysis of how much are you able to contribute to the plan in terms of disposable income every month. So I think that covers it. Well, Garry will, I'm sure, log back on. This is the wonders of technology right now. But we'll move on to question 5, which is for Milos. Can a corporation file a Chapter 7?
Yes. Corporation can file a Chapter 7, same as an individual. The only difference is a corporate Chapter 7 does not obtain a discharge. So then the question, often the follow-up question is, if they don't get a discharge, what's the benefit of filing a Chapter 7? Almost all circumstances that I've seen, I don't think there's ever been an exception. It's similar to a business dissolution. Somebody decides that their business is failing, they file the Chapter 7. The trustee liquidates the asset, the secured creditors get back their assets, and the business ceases to exist. So that's why someone would typically file a Chapter 7 as maybe a substitute for a business dissolution. One thing to keep in mind is, even though the debtor, the corporation files for bankruptcy, if you have any accounts where there's a guarantor, a codettor, or someone else that's also on the loan that did not file for bankruptcy, you can still pursue them for the debt. And that's it.
Perfect. It's that corporate Chapter 7, essentially a trustee is appointed and they wind down the affairs of the business. That's really what it comes down to. It's a trustee-assisted liquidation of the business. And at the end, there really shouldn't be anything of value left that didn't go back to a secured creditor. And then the discharge almost becomes a moot point for that business. All right, question number 6. This one is from Monette, and this one's very timely because there was a recent Supreme Court decision. So, does a creditor have to return a vehicle once a debtor files bankruptcy after the Supreme Court's decision in Chicago versus Fulton?
Well, the Supreme Court has said no, but I'm going to give you a little history and some caution here. This happened in my town. I live in Chicago, and years ago, the Seventh Circuit, which governs our courts, said that upon the filing of a bankruptcy, a creditor must return collateral if a debtor requests it. Regardless of whether, and I'm going to be talking about vehicles because this is really where this comes into play. The whole case was about vehicles. Regardless of whether the vehicle's insured, regardless of whether the debtor even has a driver's license, you have to turn that over. So for years in Chicago, we've had to turn over vehicles immediately upon filing if the debtor asks. What happened in Chicago is the city is nearly bankrupt, we all know that, and they are aggressively enforcing parking fines, traffic citations, so that many people have a load of traffic debt that they are unable to pay. And the city of Chicago, in its ordinances, is permitted to impound vehicles for unpaid traffic citations. So what was happening was, as these traffic citations and fines build up and cars were getting impounded, debtors were filing, mostly pro se, Chapter 13s in order to get their cars out of impound because they needed them for their jobs, for their life. So then the city of Chicago decided that it was not going to return them. They were going to claim a lien that gave them special rights to retain the vehicles. Well, all of the judges in Chicago that heard these cases said, no, this is a violation of the stay. Chicago, you had to return these vehicles. So on it goes up to the Supreme Court. And the Supreme Court basically said that the picture of the collateral as of the date of the bankruptcy filing is the status quo, and all that needs to be maintained is the status quo. So creditor, if you are holding that repossessed vehicle lawfully, you may continue to hold that vehicle. What does this really mean? Oh, the Supreme Court also said there's a separate provision, turnover provision, that obligates creditors to turn over property of the estate to the trustee or the debtor. So while the creditor is not violating the automatic stay by holding on to the vehicle, there is another provision that would provide for turnover. Now, just yesterday, Garry brought to my attention a case where he received a letter from a debtor's attorney who sternly demanded return of vehicle by a certain date and time and threatened to file an adversary turnover action if it wasn't turned over. Okay, that's not sanctions, that's a turnover. He did provide insurance information. Now, this is important because in Chicago, we were unable to even ask for insurance information before turning over the vehicles. Now I think you can. I think you can verify that it's insured. You can wait for the debtor to take action. Now, here's how I think reasonably and responsibly this is going to play out. You repossess a vehicle, you have it, you haven't sold it yet. Debtor files for bankruptcy, wants that vehicle returned. And let's say it's a Chapter 13. First thing you can do is ask for proof of insurance. If there is insurance, look at the plan, look at the schedules. Is the vehicle scheduled? Is the debtor providing for the vehicle in the plan? If so, you may want to just turn the vehicle over. Why make the debtor go through a long involved adversarial process, which it requires an adversary? Some judges may just allow a motion to get the vehicle back. Why? Why make them do that? They need this vehicle. That would be reasonable. If there's some reason why you don't want to turn this vehicle over, other than insurance, then wait for the debtor. Wait for the debtor to file their action and then make your arguments then. If, for instance, you don't like the plan terms, the value of the vehicle is way too low, well, that's not a reason to hold on. That could then be construed as a violation of the automatic stay because you're maintaining possession and control while demanding, a change in the plan terms. No, you can give the vehicle back, but then file an objection to confirmation. I don't know how this is going to play out. I'm talking out of experience, knowledge, and guesswork, but I think you still have to be very careful on what you ask for. Insurance is reasonable. A driver's license is a reasonable request, but plan terms is unreasonable. Now let's look at Chapter 7. What if the statement of intent says, I'm going to reaffirm, and you happen to know that this debtor does not follow through on what they say they're going to do? So should you demand a reaffirmation agreement before you return the car? I would say no. I would say if the car is insured and you want to enter into a reaffirmation agreement with this debtor, you may return the car and seek a reaffirmation agreement. If you do not want to reaffirm with this debtor, I say you can hold on to the car and that's all, and wait for the debtor to take some action. So I'm just trying to give you what I think is going to happen as we go through this and the law develops, and there will be developing law in different jurisdictions. There may be local rules that will provide mechanisms to obtain return of the car. Individual judges will have their own procedures, most likely, until some rules. There may be amendments to the federal bankruptcy rules, which I would guess will probably eventually happen. But in the meantime, we're all going to have to work within these question marks. How does this work? I think at first judges are going to be reluctant to sanction creditors that are playing a little more hardball with returning collateral because the rules aren't set. But once the rules start to be set, then you're going to have to follow them. Once you know what they are, you have to follow them. So, of course, we will keep you apprised of whatever develops. And certainly, if you run into this situation, you as always can give us a call and we will give you our best advice on how to proceed with this. But the short answer is you can just maintain possession of that vehicle without doing anything else. And I would say it's okay to ask for insurance and it's okay to ask for a valid driver's license. So that would be my comments on that.
Thank you, Monette. There is actually, I'm going to find it here, there's a kind of a related question that came up, and I don't know if anybody wants to weigh in on it. What happens when one of our clients' automobiles gets impounded? We've had that situation.
Yes, and I can kind of handle that. I've had a little experience because of the Chicago issues with impoundment. Really, the question comes down to one of two things. Do you want to recover the car and sell it? And if you do, then you're going to have to pay those impound fees. If the debtor's in bankruptcy, especially at Chapter 7, you're never going to see that. You're never going to see those fees. So that's a business decision. Is this car worth it in order to pay those fees, recover it, and sell it? I did have a case where a creditor said, I don't even know what shape this car's in. I'm like, well, now you're in, that adds a twist. Maybe you can go to the impound lot or have somebody go there to actually look at the vehicle and make an appraisal. But, that's a risk you're going to have to take. Sometimes if the fines aren't so bad, the debtors will want to pay these fees, and maybe we'll be seeing more Chapter 13s where the debtors actually file and intend to pay all of their fines instead of just filing and letting it get dismissed because they got their car back and that's all they really wanted. It's a business decision. Is it worth it to pay those fees? Are you going to be paid in full? Or the debtors may say, will you please pay that and give the car back to me? Well, then you've got an additional claim. You're taking a risk as to the debtor. You've got an additional claim for those fees to add on to your debt. That may be an administrative proof of claim that we can file for you, which will give it first priority. But that always entails risk for the creditor, whether or not you want to do that. And it's really a business decision. So.
And I would go a little further and even add, one of the most popular situations we get is not only is it impounded, but depending who impounds it, the fees are just unreasonable. They're just kind of crazy. And what I would say to you is what they're demanding isn't necessarily what you have to pay. It is negotiable, and there may be some state law out there that will govern how much they really can charge per day. And you may have some positions you can take which pushes back on the amount that they're looking for. So my answer would be reach out to us if you have a situation like that where the fee is certainly more than nominal and it seems exorbitant or excessive, and either us in the bankruptcy group or our counterparts that handle replevins can make some inquiries for you or look into it on a state-by-state basis and determine, yeah, we think you got some defenses here, or no, you're going to have to pay it all. At least to the next point, you can make a business decision then. So, all right, we're going to go on to question. Now, we're going to actually, for a moment, skip ahead one question because Gary is trying to log back in, and we're going to wait for him, and we're going to let question 8 go. Skip 7. Okay, so question number 8 is for Milos. Milos, when a creditor obtains relief from stay in a bankruptcy, is the debtor required to return their collateral?
This is not going to be the popular answer, but the answer is no. I get this question a lot, and I think to help understand it, I have to explain exactly what a relief from stay does for you. When a debtor files for bankruptcy, there's an automatic stay in place that is by statute, which takes effect as soon as the case is filed. So what that means is taking any action to collect debt against a debtor while he's in the active bankruptcy is prohibited. This includes, repossession of vehicles and foreclosure on houses. The reasoning behind the automatic stay is to provide the debtor with temporary relief while he has an opportunity to get his finances in order and work his way through the bankruptcy. Under certain conditions, if the conditions are met, a creditor is allowed to terminate that stay with regards to certain assets which serve as collateral for the loans. Once we obtain that relief from stay, all that does is lift that protection that the debtor was getting in the bankruptcy. It doesn't guarantee you anything. It doesn't guarantee your collateral. It doesn't sell your collateral. It doesn't get you any money. It just basically states this asset that the debtor had is no longer protected by his bankruptcy. So you can go after and do whatever you need to do. Now, if the debtor is not willing to voluntarily turn it over, or if you try to reach out to, it may be worth reaching out to his attorney to see if he'd be willing to make arrangements with his client. A lot of times they'll either ignore you or they'll try to keep the car as long as they can. Your only recourse is to go through your state court and use your state court powers and the statutes to recover the collateral, which you could repossession. And if in extreme cases, if they're hiding the car, if there's other issues, replevant. But the bankruptcy court relief order does not force the debtor to return the collateral. It just gives you the permission to pursue the collateral the way you normally would absent a bankruptcy. So that's all I had on that. I don't know if anybody has anything else to add, or if there's any, Scott, I don't know if there's any follow-up questions to that one.
There are not, and I will just add, I can personally tell you, I've had this discussion with many of the judges that I appear before throughout time, and the answer is always the same. It is, once that stay is lifted, that car is or whatever the personal property is, it's no longer property of the estate. The bankruptcy judge does not want to be in the business of ordering people to turn that collateral over. They will, every single time, they will tell me, go to state court. I've done what I can do. I've given you relief from stay. You now need to avail yourself of your state court remedies. So it is what it is. I'm sure there's a bankruptcy judge out there somewhere in the country who's, there was an egregious enough set of facts, and maybe they ordered something. But pretty much the standard answer you're going to get in the bankruptcy court is after you get relief from stay, that is your issue, and you've got to deal with it through self-help or state court remedies to actually get the collateral back if the debtor's not cooperating. So again, Milos is right, not the answer you want to hear, but it is the legal answer. All right, Gary, are you on audio? I'm going to give him a chance here. Didn't think so. He's trying to get on by audio. So why don't we do this? Why don't we go to question number 7, and I will take question number 7 for Gary. So let's go backwards. Okay, so the question is, a debtor was provided a forbearance on their mortgage due to COVID-19, which obviously many of us have seen these forbearances being offered. What happens next, and what does the creditor need to watch for? All right, so Congress recently provided some additional resolution or some clarity on this issue through the Consolidated Appropriations Act of 2020. That was passed back in December, and in reference to federally backed mortgage loans in Chapter 13 bankruptcy cases, it basically provided if you're a servicer of a federally backed mortgage loan, you now have the ability to file a supplemental proof of claim in the bankruptcy case for payments that were deferred under the CARES Act forbearance agreement that you haven't received yet. So a supplemental claim is allowed even though the bar date has passed, as long as you have not yet received the payments, and the claim is filed within 120 days after the forbearance period ends. So there's your clock ticking. 120 days after the forbearance period ends, you've got 120 days from then to get that supplemental claim in. The supplemental proof of claim filed under the CAA, the Consolidated Appropriations Act, must include the terms of the modification or deferral, a copy of the modification or deferral, if it was made in writing, and a description of the payments that were deferred. If you file that supplemental proof of claim, the Act also provides the debtor 30 days to file a modified plan that will provide for that claim. If the debtor doesn't file a modified plan within that 30-day period, any party in interest, such as the court, trustee, the bankruptcy administrator, or the creditor, can file a motion to modify the plan to provide for that claim. So the big takeaway here is revisit your processes. Make sure that you are filing supplemental claims if you have one of these forbearance issues, and that you monitor the docket for a subsequent plan modification. If it's not filed within that 120-day period, the supplemental claims are going to likely be barred as they're out of time. But as of now, these provisions will be in effect. They're starting in December, till December of 21. So from December of this past year through the end of this year. So that handles the forbearance issue under the CAA. So now, why don't we move on to number 9. Number 9, this question is from Monette. So a customer calls in and states that they filed bankruptcy. Can the organization speak to them if they call requesting general account information?
Yes, you can do that. But only if they call you, and I would restrict the conversation to only giving them account information, nothing else. You may ask for bankruptcy information. What's their case number? What court did they file in? Who is their bankruptcy attorney? That's perfectly legitimate. But anything else, asking for payments is a major no-no. Asking for how the plan is going to treat their debt, that's a no-no. Are you going to reaffirm? Don't go there. That could be construed as an action to collect a debt, which would be a violation of the stay. So you may cordially speak with someone who's filed bankruptcy, give them information about their account. For example, what's my balance? You can tell them. What are the arrears? You can tell them. But if they want to discuss more than that, you will, and sometimes they'll be fishing for legal advice, even though you're not an attorney. They don't know. They have questions. Refer them to their attorney. If you start to get uncomfortable with what they're asking, refer them to their attorney. Now, if you have a very, very insistent debtor that really wants to dive deep into this, you can always say, I need to consult with my attorney, and my attorney will then contact your attorney. And that's really only in the most situations where you're the most uncomfortable and you really do need legal advice. But you can also say that just to save yourself and get out of it and give me a call and say, hey, I want you to contact this attorney and tell their debtors not to call us anymore unless they want just basic account information. That's legitimate. You can do that. So I would say it's fine if they call you and they want account information, but don't ask them anything except for their bankruptcy information, the case number, their attorney, and what court they filed in. So.
Fair enough. I see Gary is back with us. Can we hear you?
Yes, hopefully you can.
Yep.
Yes, we can. We can, just in time. All right. So, Gary, this next one is for you, question number 10. So, the question, and it's actually, we got a question that is very closely related to this, so I believe this will cover it. It's what are the differences between a case being dismissed, a case being discharged, a discharge withheld or denied, a discharge revoked, and a bankruptcy closing? It's a lot, I know, but walk us through it.
Sure. So generally, when you see a case is dismissed, it normally indicates the debtor has failed to do something. They failed to file some document, they failed to make plan payments, and this failure on their part has resulted in the case being dismissed. So once the case is dismissed, you can proceed normally outside the bankruptcy. However, you need to remember that until the bankruptcy case is actually closed or terminated, is how you sometimes see it designated, you should be aware if a debtor does file a motion to vacate the dismissal order and the court reinstates the case, because then you don't want to be in a position where you're possibly violating the stay that's now back in place. As far as discharged, in a Chapter 13, this means the plan has been completed and the debts that are eligible to be discharged per the plan and the bankruptcy code have now been discharged and cannot be collected upon. In a Chapter 7, this means the eligible debts have been discharged. If you had a secured debt, however, your collateral rights and your lien rights may still survive that discharge. As far as a discharge withheld and denied, generally this will happen if a complaint objecting to the discharge has been filed and if that complaint has not been decided in the debtor's favor. Or if the debtor is in the time period in between two bankruptcy filings where they previously received a discharge and now, because of that time period, cannot obtain another discharge. So how this works, if they previously filed a Chapter 7 and they're now filing another Chapter 7, there has to be 8 years in between those filings. If they first filed a Chapter 13 years ago and they're now filing another Chapter 13, there has to be 2 years in between those filings to get a discharge. If they previously filed a Chapter 13 and they're now filing a Chapter 7, there has to be 6 years in between filings. And if they previously filed a Chapter 7 and they're now filing a Chapter 13, there has to be 4 years in between filings. Other reasons why it could be withheld or denied: debtor may not have paid the filing fee or some other court fee in full, unless the fee was actually waived by the court. They may have failed to file certain documents, such as tax documents, with the court. Or one we see pretty often, relatively, is the debtor has not filed their certificate of their personal financial course completion. One thing to remember here also with the discharge withheld is the debtor may come back later on and cure the issues if it's for example, the financial course certificate or fees, and later obtain their discharge. So that's something to keep in mind. As far as a discharge revoked, generally this will happen when a trustee or creditor files for the revocation with the court. Many times this will happen if fraud has been uncovered either by the trustee or creditor that was not discovered until after the discharge was granted, and it's something that could not have been discovered at that time. If the discharge ends up being revoked, the debts are reinstated, and the debtor could be pursued now for the debt that was previously discharged. Other reasons for why revocation might happen could include debtor's failure to obey certain court orders. Again, they failed to produce certain required documents, or they failed to disclose some assets that would have been property of the bankruptcy estate. And then finally, a bankruptcy case closing will happen in any of those situations. And it means that the case has either been previously dismissed, the debtor's received a discharge, and now this is the action of the clerk closing the bankruptcy case. Sometimes you'll see a designation on the docket that there's been a discharge and there's an appeal period. After that appeal period, or shortly after, the clerk should be formally closing the case. You'll see either on the docket that the case is closed, and or you also will see it designated that the case has been terminated, or you'll see a termination date. That also indicates the case has been closed after whatever previous result in the case.
Thank you, Gary. So to the attendee who asked the question, if we receive a case closed without discharge, are we able to collect on the debt that they had in the bankruptcy? Just so you guys you're clear, the answer is you are able to collect on that. It does survive the bankruptcy with a big but, and the but is make sure you keep an eye out, at least certainly for the first 30 days and for a little while after, because the debtor might go back in and have that case reopened, because if the only thing they didn't do was file their certificate of completion of a financial management course, they usually fix that. So you may think that it's closed without a discharge, and then 30 days later, it'll all get undone and they'll get their discharge. So be a little bit careful with that. You can certainly start down the path of collecting, but if you get an inkling or they tell you, no, I went back and fixed it, either check it or have your counsel check it for you to make sure and verify. They may end up getting their discharge after all. So,
Scott, I have one more thing I just want to add, just for people to be cautious about it. It's not uncommon for somebody to file a 13 shortly or immediately after filing a Chapter 7. Just one thing is, don't get distracted by the 13. If the debt that you have was discharged in the 7, a common scenario would be They filed a 7, they got a discharge of all their debts, they turned around and filed a 13 just to take care of their secured debts, which would be a car and a house. That 13 fails and it gets dismissed. They wouldn't have gotten a discharge anyway, but that discharge that they previously had carries over if your loan existed at the time that case was filed. So filing a new case doesn't, restart the process or reobligate them on your loan. So those discharges are forever.
Excellent point. So I think the takeaway for our clients is if you've got debtors with multiple bankruptcy filings stacked up against each other in a period of years, my advice is seek advice from counsel, seek advice from us, and let us analyze it, and we can tell you, was this debt discharged in a previous bankruptcy? Did it survive the current bankruptcy? But I think we've given you enough flavor here to make you dangerous, but if you have any doubts, please come to us, and we're happy to look at it for you. All right, so next question. This one's for Milos. What secured loans can have their claim amounts reduced in a Chapter 13?
Once again, unpopular answer, all of them. It really depends on the circumstances. I guess we'll go through every single one. I'm not going to dwell on it too long. We can do an hour just talking about this. But a debtor's primary residence cannot be, the secured claim cannot be reduced. But if there is a wholly unsecured claim, for example, debtor has a house that's worth $100,000. They have a first mortgage for $100,000. They have a second mortgage for $50,000, and it's their primary residence. If there's not enough equity for any subsequent mortgages to attach to, they can actually get those completely stripped in a Chapter 13 bankruptcy, and that hinges on value. If there's even a penny of equity for that second mortgage to attach, they cannot do that. But also keep in mind that if your secured second mortgage or third mortgage or whatever gets stripped, that's only permanently stripped if they successfully complete the Chapter 13. If that 13 gets dismissed or fails for any reason, your mortgage is still in place. Also, you need to be aware that mortgage will be paid as a general unsecured creditor for the duration of the plan. So there's still a possibility that you'll get a significant amount of money even if that mortgage does get stripped. For non-residential real estate, that'll be any real estate that debtor owns that they do not use as a residence, they don't live in, they can reduce the secured claim to the value of the collateral. Motor vehicles, they can only do so if the loan is 910 days or older. If the loan is less than 910 days old, they cannot reduce your secured claim for a motor vehicle. Even if it is more than 910 days old, they can only reduce it based on the value. So that's going to hinge on what the car is worth. And lastly, everything that's not a car or a house, they can cram it down if it's a year or older. And then once again, that comes down to value.
Thank you very much. All right, so the next question, and the one Milos just answered, and this one also were submitted by attendees. So this next question is from Monette again. It's a customer files a Chapter 7 and gets a discharge before a reaffirmation agreement was filed. Then the vehicle gets repossessed. Should the lien holder provide the notices required under state law? And is the lien holder able to discuss a cure of arrears and a return of the vehicle?
Okay, well, upon discharge, the stay is dissolved, so there is no stay in effect. You are free to sell that collateral that you have in your hands, but you also must follow state laws. Nothing changes. It would be as if the bankruptcy never existed now and you want to proceed to sell your collateral. Whatever your state provides for that you must do, notices to the debtor, you must follow through on. You also may contact the debtor. There's no stay in effect. I would advise against that. Sometimes the debtors will call you and they will want to work something out. What we call retain and pay. They want to keep the car and they want to continue to make payments with you. You may discuss what the payments are under the contract. You may discuss what the arrears are. You may not ask for payments. Why? Because this debt was discharged. Your only legal remedy now is to repossess the vehicle, which you have done and you have in your hot little hands. It is your discretion if you want to turn this vehicle back over to the debtor and allow them to resume payments. But the caveat is you may never ask them for payments. You will simply have to repossess the vehicle again if they default. So this is probably not something that you would do on a regular basis. I would probably say you'd want to just go ahead and sell your collateral. But you may discuss it with the debtor, but you may never ask for payments, and you may never pursue them for payments. Your only remedy is what you would get upon the sale of the vehicle.
Thank you very much. All right, so Gary, this next one came from an attendee, and this will tie into the following question if we get to it. But the question for you is, what's the outlook for private student loans and bankruptcy?
So at the outset, I'll say it's not surprisingly, a lot of it's an unknown, or we're in a wait and see what's going to happen. So we do anticipate that at some point in the future, possibly this year, there will be some legislation that's introduced that may be beyond what's already been introduced. You may have heard that there's been some discussion in media of loan forgiveness. If you've heard the $10,000 amount forgiveness or $50,000, that's in reference to federal student loans. But as I mentioned, it's quite possible we're going to see additional new legislation once Congress gets past the stimulus bill they're working on and everything. And quite possibly the legislation is going to be trying to approach this through changing the bankruptcy rules and regulations to allow for further discharge. There was a bill that was recently introduced this month by a group of 4 or 5 senators, which was titled the Medical Bankruptcy Fairness Act of 2021. It's just at the very beginning. There's not a whole lot of details out yet, but this bill proposes to allow student loan borrowers to discharge their student loan debt in bankruptcy. But as I mentioned, the details are sketchy at this point. It's unknown if this is going to apply to just debtors who file new cases going forward, to debtors who just have certain medical debt. Is there a certain amount of medical debt? Is it going to include debtors who can claim they've lost their job due to COVID shutdowns? Or is this going to be a change across the board? We also need to wait and see, when they mention student loans, are they talking about federal student loans again? Or are they including private student loans? Is it one or the other? As well as, are there going to be monetary parameters on any potential discharge? It's also possible that they could try to take aim on the undue hardship provision, which is, as we all know, very central to student loan discharge cases in the private setting. Or aims at targeting that. So unfortunately, the general answer is there's much uncertainty this year until we actually see what Congress is going to do, what their intent is. And also something to keep in mind is, what kind of support are they going to get? And when I mention support, I mean on the vote level in the House and Congress. One thing that may work in a creditor's favor, at least at this point, is both the House and Senate are very tightly divided. And so it could be, if you have, 1 or 2 senators that cross the aisle and disagree with some legislation, that could kill the bill. So that's something to keep in mind, and we're going to continue to monitor, because it could change really quick, or it could take a while.
Thank you, Gary. So I'm going to respond to a question that came through while we've been talking. The question is, what happens if the reaffirmation agreement is submitted, but the debtor is discharged prior to the hearing to be held for the reaffirmation? So here's what I'm going to say to that. If I understand the question, creditor has gotten the debtor to sign the reaffirmation agreement, and I believe they're saying, well, we submitted it to court. So if it's been filed before, let's make it simple. If the operative date in every Chapter 7 case is the discharge. You have to get a reaffirmation agreement entered into before the discharge is entered. If you have a reaffirmation with your customer and it's signed by you and by them on the date before the discharge is entered, you can still get it filed. The key operative date is when you entered into it. But obviously you can't wait too long until the case closes. Now there's no more case to file in it. But I think that's kind of what you're asking me, is if the date passes, is it too late? The answer is, as long as you get it, if you enter into the agreement before the discharge date, you should still be able to get it filed, but I would not wait very long. It should be a matter of if it's the day after and you want to file it, it can still be considered valid as long as it was entered into prior to that discharge date. But do not wait. I'm going to also touch on a question we got from an attendee asking us to go into detail on the Consumer Bankruptcy Reform Act of 2020, which is not a real thing yet. It's a proposed legislation that Senator Elizabeth Warren has put forth. And I know we only have a couple of minutes here, so I'm just going to give you the high points or the low points, depending how you want to look at it. Basically, what she is proposing is that there no longer be a Chapter 7 and Chapter 13. Instead, she is proposing that those be replaced with a new Chapter 10. And this Chapter 10 would allow for both Chapter 7 and 13 scenarios to occur. If you are a debtor whose annual income falls below 135% of the median income in your region, you would qualify for what's called a no payment discharge, which basically sounds just like a 7. You don't have to repay your creditors. You just get a no payment discharge, and it's as if you filed a 7. The new wrinkle is both private and federal student loan debt would be dischargeable under her plan, both in Chapter 7 and Chapter 13. So there's your big difference. And the most popular question that we get right now is, when are you going to see a bankruptcy spike because of all this pandemic stuff and the moratoriums, and is there going to be a big foreclosure rush and all that stuff? And my answer is now really starting to become, I don't know that we're going to see a spike in bankruptcies because of COVID and the foreclosure moratorium being lifted. I think what we may see a bankruptcy spike result from is if something like this were to pass. Do I believe that this is going to pass? Not in this current form. I think there's a lot of opposition, both amongst bankruptcy lawyers and Chapter 13 trustees. I don't think that this is something that's going to pass in its present form. But let me go backwards. I talked about if you're a debtor whose income falls below that 135% threshold, you can just get a no payment discharge. If you're a debtor whose income is above the 135% median income threshold, or you have secured debt that you want to repay and cure arrears on, you have an option to file 3 different types of repayment plan. There's one for unsecured debt, there's one for mortgages, and there's one for every other kind of secured debt. And you can file 3 different plans all in the same case under her proposal and repay your debts that way. A couple of big things to note in this legislation if you are a secured creditor. Number one, it would allow for the cram down of residential mortgages secured by your principal residence. As Milos said, currently you can't alter or modify the first mortgage on your principal residence in a Chapter 13. Whatever the terms are, they are. Under Senator Warren's proposal, you could cram it down to the value of the home. Number two, the 910-day rule that Milos discussed would now become a 90-day rule. So any auto loan that is more than 90 days old could be crammed down to the fair market value of the vehicle. And thirdly, the codettor stay would apply in all chapters of the Bankruptcy Code. So it wouldn't just be in Chapter 13 or Chapter 12. And one other item, the credit counseling requirement would be eliminated across the board under Senator Warren's proposal. So with that being said, that's a very high-level version of that bill as it exists, and we'll see what Congress does with it if they do something with it. And we'll continue to update everybody and post some stuff on this as it moves through Congress. But with that, We have reached the end. It's noon, I see. So I want to thank everybody for attending today's webinar. We hope you found this informative. And to see all upcoming Weltman webinars, please visit the event tab on our website, weltman.com. Thank you for attending. Have a great rest of the day. And if you do have questions, by the way, that we didn't answer, feel free to reach out to any of us, and we'll do our best to get them answered for you. Okay? Thank you. Have a wonderful day.